Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Now, lawyers for embattled Ashanti Region NPP Chair Bernard Entwi-Buesiakon, also known as Chairman Wontumi, have filed an application seeking to defer judgment in a Summer Boy case. Now, Wontumi's lawyers are set to move the application on Monday, July 20th, the date set by Justice Kokuvi, to deliver judgment in the matter in which the NPP regional chair and his company have been accused of engaging in illegal mining. Now, according to them, the judge must defer her ruling until the determination of some constitutional questions pertaining the Minerals and Mining Act. Judgment in the case was initially deferred from July 3rd after an extension of time to have Wontumi's lawyers file their written statement. In the court, state prosecutors have asserted that former Men's Gold CEO Nanapia Men's incorporated brew marketing consult after Men's Gold's then Men's Bank got into an agreement with the government to purchase and export gold. The prosecution began cross-examination of the former Men's Gold boss after he completed his evidence in chief on Friday. Namuan is facing multiple charges, including money laundering, defrauding by false pretenses involving over 340 million cedis, fraudulent breach of trust, selling gold without a license, and operating a deposit-taking business without authorization. Meanwhile, spokesperson for the aggrieved Men's Gold customers, Fred Forson, says he continues to be haunted by some of the debt victims after years of the failure to have their monies repaid. Lord Edu Asare is our court correspondent with more on this story. Now, Lord, let's talk about court proceedings today because two important issues have taken place. The first being Chairman Wontumi's Summer Boy case. Talk to us about that, and then we'll go on to Namwa.
Right, Kimni, so like you outlined, indeed, Wontumi's lawyers have filed an application at the High Court for the presiding judge in the matter to refer some constitutional matters from their submission of their final submission that they expect the court to rely on to make their judgment on 20th to the Supreme Court before, after that is determined, then the judge can then make a pronouncement regarding the case. Now, among other things, they indicate that, for example, sections 14.1, 59, at 992 of Act 703 as amended by Act 995, on which charges the court based on or anchored on to order Wontumi to open his defense as regards the submission of the law case which they dismissed hasn't been determined by the Supreme Court, and so it sort of raised a lot of questions around those charges. Now, particularly, they mentioned two of the charges which vote against Wontumi, which is the count 4 and then count 6, which has to do with him facilitating illegal mining operations, the Summer Boy concession. Now, they indicate that the Supreme Court has not really determined or given a particular ruling on this matter, and it's bothered on that, and so they need to refer these constitutional questions to the Supreme Court, after which, when it's determined, then the make pronouncements or the judgment in Wontumi's case. So essentially, they are asking the court to halt the proceedings and then refer these constitutional questions to the apex courts for interpretation and then final determination before they can continue with the decision by the High Court of Kimini.
I see.
From that.
And what's been prosecution's response to this?
No, the Deputy Attorney General, he responded to it, indicating that, actually on two grounds, citing that the fact that an accused person or a party makes some allegations regarding charges does not give the court the mandate, or the court is not obliged to defer or refer the case to the Supreme Court, essentially halting is that they can go ahead with the decision of the court. And then also indicated that the question that they claim constitutional questions for which reason they are asking the Supreme Court to make a determination are not ones that can class as constitutional questions, because they don't there's any weight as such. And so he's asking the High Court judge to dismiss their application and then move forward with their with the judgment, which is based on next week Monday, which is July 20 Kimini. And so it remains to be seen, because the lawyers are hoping to move that motion on Monday when the case is called, and if the ruling goes in their favor, then possibly the courts will adjourn or defer the judgment again, because you realize that the initial date for the judgment was on 6th, and then it was adjourned to 20 after the judge allowed the lawyers for Wontumi to file their final submissions in the case. Now, on 13th, we reported that they were yet to file the written submissions, but by close of the day, they had filed that submission, and then included the constitutional question that they expect the courts to make the decision on.
Very well. Do we have word on that plea bargain in the Exim Bank case?
Well, they were given for 14 days to conclude on that matter. And so as far as the Exim Bank case is concerned, both parties, which the prosecution and Wontumi's lawyers, are still negotiating. They've been given the next date to come to court to give an update to the court on where they are as far as the plea negotiations has gotten to. The last time they were in court, they indicated to the presiding judge that it's progressing smoothly, but they still have some fine touches or nuances that they need to complete on, since they still are within the prescribed number of days that they can make the plea negotiations. And so once that has not been elapsed, they still have time to make sure they fine-tune the little details in the negotiation before they can come to the High Court to give them the update.
I see. Let's talk about NAM1, because prosecutors are now trying to determine whether or not at the time he transitioned from Men's Bank to Men's Gold, he had license to sell. What are we learning?
Interesting development there, Kimini. So NAM1 initially was making oral evidence, and she was giving his evidence orally, but then was directed by the court to file them in a written, file his evidence or testimony in a written format, because it was kind of a stretch. Now he completed that today. He was led by his lawyers to finish his evidence in chief, after which the prosecution, led by a principal state attorney, Watkins Adama, cross-examined him. Now, know this, Kemini, although NAM1 is representing Men's Gold and then Brugge Marketing Consult, both companies, he is testifying for only himself, which is him as an individual, as a CEO of Men's Gold. Now, both Men's Gold and then Brugge Marketing Consult, he will not be a witness to these companies. They're expected to file their own witnesses, although Kemini, NAM1 is the one who is standing for both companies, saying that both companies, he's representing them. Now, when it came to the cross-examination, the principal state attorney sought to establish that he, over a period of time, first changed the company name from Men's Bank with a K to Men's Bank with a C. And NAM1 answered that it was based on the advice of the Bank of Ghana, highlighting that the central bank, was very much interested in this bank because their business was novel, and so the central bank paid critical attention to them. Now, he indicated that after changing the name from Men's Bank with a K to Men's Bank with a C, they got an agreement with the government in August 2016 for essentially him to sell gold to look infamous. Now, he indicated that, this is the prosecutor, he indicated that afterwards, that's when NAM1 set up the company, which is Brugge Marketing Consult. Now, he sought to establish that after that agreement with government, NAM1 set up the company Brugge Marketing Consult, in which he has 70% shares, and then 3 people have been cited as directors, he, his wife, and then 1 other person. So they're the sole directors. And then he sought to benefit from this initiative or agreement that he had with government. So that case has been adjourned somewhere next 28 for the cross-examination of Nana Piamens and NAM1 to continue.
A bit more in terms of details from you as the days go by in relation to this particular subject matter. We're hoping to get a bit more as well from Inusa Fusheni. He's a former member of parliament. He's a private legal practitioner as well on these aspects in relation to concerns, right? They say that they had wanted ordinary person to be at least a person reaching a tertiary level, that specifics as to a majority arriving at a decision would mean that the ordinary persons could override the chair of the tribunal amongst other things. And so they are hoping the president will not assent to it. But if he should, then we could see possible challenges as well coming forth in the coming days.
They still got a ways to go, and the Trades Union Congress has been chiming in. In fact, the TUC says it stands opposed to the re-establishment of regional tribunals across the country. Now, the Congress argues that bringing back the tribunals would revive painful memories of a chapter in Ghana's history it describes as bitter and unfortunate.
We gonna roll the union on.
The TUC is manifestly opposed to the idea of resuscitating tribunals, given our collective bitter experiences with tribunals. The tribunals bill in its current shape and form strengthens our conviction that tribunals must be abandoned. The bill, when passed into law, can be a potent tool for weaponizing justice delivery and entrench the perception held by many that our justice system is up for grabs by the politicians. We call on the President and Parliament to heed the advice of the Constitution Review Committee, and government must halt the current legislative process of enacting the tribunals bill, expunge regional tribunals from the Constitution, and take meaningful steps to properly resource our judiciary. If law is properly seen as an embodiment of our collective historical experience, then the recent history of public tribunals must lead us away from any attempt to re-establish regional and district tribunals. The bill must be withdrawn from Parliament.
Now, 3 legal professionals from different backgrounds have been nominated to Ghana's Supreme Court, bringing together decades of judicial experience, international human rights expertise, and private legal practice. While 2 of the nominees are serving Court of Appeal judges, the third is the former president of the Ghana Bar Association, making the rare transition from private practice directly to the country's highest court.
Justice Sophia Rosetta Oduokwa Benasco Esa is widely regarded as the career judicial officer among the 3 nominees, currently serving on the Court of Appeal. She previously worked as a state attorney before entering private legal practice and later joining the bench as a High Court judge in 2011. She was elevated to the Court of Appeal in 2019. Her judicial work spans commercial disputes, land litigation, banking, employment, and administrative law. Justice Benasco Esa's nomination is significant because it is her second attempt at joining the Supreme Court. Former President Nana Addo Dankwa Akufo-Addo first nominated her in 2024, but Parliament did not complete the approval process before its term expired. During her earlier vetting, she advocated greater digitalization of the courts, wider use of alternative dispute resolution, more court infrastructure, and public education on the justice system, while insisting judges must remain guided solely by the Constitution and the law. Justice Edward Amwako Asante brings extensive regional and international judicial experience. A Court of Appeal judge, he previously served as president of the ECOWAS Community Court of Justice, where he led reforms including electronic case management and virtual court hearings across West Africa. His work at the regional court covered human rights, arbitrary detention, freedom of expression, political rights, and fair trial guarantees. In 2025, he was elected to the United Nations Human Rights Council Advisory Committee, reinforcing his international standing in human rights and public international law. Justice Asante also served as a High Court judge and supervised more than 30 courts in the Western region, combining judicial administration with decades of courtroom experience. If approved, questions are likely to focus on how his international responsibilities would fit alongside service on Ghana's apex courts. The third nominee, Anthony Forson Jr., offers a different perspective. Unlike the other nominees, he has never served as a judge. Called to the bar in 1997, he built his career in private legal practice, specializing in commercial litigation, before rising through the ranks of the Ghana Bar Association to become its national president from 2018 to 2021. Throughout his tenure, he championed judicial independence, legal education reforms, professional ethics, and stronger action against corruption. His nomination continues Ghana's constitutional practice of occasionally appointing distinguished private legal practitioners directly to the Supreme Court. However, his parliamentary vetting is expected to examine his judicial philosophy, potential conflicts arising from previous legal practice. If approved by Parliament, the 3 nominees would bring distinct strength to the Supreme Court. Justice Benasco Esar, with deep experience in Ghana's domestic courts, Justice Amako Asante, with regional and international human rights expertise, and Tony Forson Jr., with decades of courtroom advocacy and leadership within the legal profession. Together, they will shape the composition of Ghana's highest courts at a time when constitutional interpretation and judicial independence remain under the close public scrutiny.
This afternoon, mixed reactions have greeted Parliament's decision to pass the controversial Public Tribunals Bill, which is aimed at establishing a legal framework for the operation of tribunals in the country. After a marathon sitting that stretched past midnight, Parliament passed the bill despite stiff resistance from the minority, which boycotted the approval process. The legislation seeks to establish regional and district tribunals across the country to handle specialized cases, including illegal mining, tax and custom offenses, fraud, and cases involving economic loss to the state. Government says the tribunals will help speed up the prosecution of complex public interest and economic crime cases and improve access to justice. But critics have raised concerns over the timing and the need for safeguards to ensure the tribunals remain independent. Here are excerpts of the debate from the Majority Leader Mahama Ayariga and the Minority Leader Alexander Penyumarkin before the passage of the bill.
The Foreign Affairs Minister was in the Volta region with the President, and I called him and he came back. There are people who came all the way from Northern region. There are some of our colleagues here who were in Yendi to attend the 3 days, Adua of our late King Diana. Because of you, I have brought all of them back. I can assure you that even if we will sit here till tomorrow morning, this bill will pass it today. We will pass it today. You can filibuster, you can do all the things that you want to do. I have your time. I have your time. We will pass this bill today. So you can go on. You can go on. Those of us who have done student politics, this is common. We go for a Nooks meeting and we filibuster until 4 a.m. when everybody is sleepy. Then that's when we take the vote.
Yes, Minority Leader.
When the Majority Leader speaks with all his authority, he says, today. He says he will pass. Mr. Speaker, the Constitutional Review Committee has spoken against this bill. They said they will do what they want to do. Mr. Speaker, we are Democrats.
The Tribunal Bill 2026 is now duly read for the 3rd time and passed.
Well, I want to bring you a bit more in terms of this tribunal and where it's come from, because we know, amongst so many things, that the NDC had this captured in their manifesto, and that's where I'm going to take you right now this afternoon onto our dashboard to get a bit more in terms of perspectives and what this new tribunal is seeking to do, amongst many other things. Because as the criticism continued to come, there's also justification from some quarters as to why this could be an important in terms of justice delivery in the country. And so if you go into the 2024 manifesto of the now governing NDC, this is what they say with respect to the judiciary and tribunals: to support the Chief Justice to establish regional tribunals as provided for under Article 142 of the 1992 Constitution, and also pass legislation to reintroduce community and circuit tribunals. And so what we know is that per the court structure, the judiciary, regional tribunals are captured in the 1992 Constitution, Article 126 to be specific, which details the various superior courts in the country, the Supreme Court, the Court of Appeal, the High Court, and then regional tribunals. So that's been catered for in the Constitution. This aspect about passing legislation to reintroduce community and circuit tribunals is what chiefly as well was contained amongst many other things in that bill which was passed yesterday, as well providing a bit more in terms of details for the constitutional provision of regional tribunals in the 1992 Constitution as well. Now, they also say they are to review the Alternative Dispute Resolution Act 2010, Act 7982, establish ADR clinics at the community and district levels, operationalize the Independent Tax Appeals Board, ITAB, and other commitments they were seeking to make. Speed up, right, the determination of cases through automation and the introduction of a judicial shift system under the 24-hour economic policy. With regards to this, we've seen the introduction of afternoon courts by the current Chief Justice, where a number of cases are seeing them hearings are starting in the afternoon, which is, according to some of the lawyers we've been speaking to here, it's provided for a bit of speed as well in terms of the progress in case delivery and all of that, that you do not have to wait long just to pick a date, amongst other things. Now, they also add that they will fully implement the e-justice project, right? The e-justice project, which is to see a lot of digitalization within the court structure and the court system, such that filing of papers and then the documentation, which can be laborious sometimes, and arguments can come about finding dockets and what have you, can be taken care of by this as well. And also introduce virtual hearings for selected cases. It's been piloted to a great extent, this on a number of cases, right? A number of cases which we've seen that has happened. But of critical importance as well, use artificial intelligence and automation to improve justice delivery as well. So these are the recommendations. Establish high courts in the 6 newly created regions where they do not currently exist, and establish courts of appeal in the western, northern, and Volta regions as well. I'm going to take us onto the phone lines right now and speak to Kwame Enyimadu Enchu, who's a ranking, right, on Parliament's Constitutional and Legal Affairs Committee, to pick a bit more from him as to this. Honorable, I appreciate you for joining us this afternoon. Walk us through the decision by your side in vehemently opposing this bill, and which aspects of it you say should not be countenanced at all.
Okay. Good afternoon, sir, and to your listeners and viewers. We have gone through the reading of the bill, the first reading, after which we went to a committee meeting. After the committee meeting, we did the second reading, where we spoke about the principles of the bill. Now, at clause 4 of the bill creates the regional and district tribunals. That is what the bill seeks to create. So an amendment was proposed from our side that even though there is a mention of the regional tribunal in the Constitution, we have far moved away from tribunal system. And the creation by an act would not be the best. So we proposed an amendment. And the amendment was opposed. So
where the amendment was asking for what?
The amendment was asking for deletion of the clause that creates the regional and the district tribunals, the creation of it. So that one was objected by the majority. At the time we did that, I think about 23 people, or not more than 30 of the NDC members, were in Parliament. The leader of the House, Honorable Ayariga, then said that he is calling for us to go into recess. We went to recess, and he marshaled all his people. He called for a 3-line whip, and almost all of them came. So we stayed from 5 p.m. when the House was suspended until about 10 p.m. when they were ready for us. When we went there, we continued. And then we realized that there was nothing we would do that they would listen to us because they had the numbers.
Right. Honorable, I want us to go back to... All right.
And let me learn, please.
Right.
And Honorable Ayariga himself said that whatever we did, they were determined to pass the bill yesterday. So we have to wash our hands off from the bill that we call it is. We say that it is not a good bill for Ghana.
I'll come to the additional aspect of why it is not a good bill. But clause 4, you say you were proposing a deletion of regional tribunals and then district tribunals. Listening, that speaks to the heart of the bill, which was before you as members of Parliament. Wouldn't a deletion, at least from what I'm understanding, have rendered the entire bill moot, since they were seeking to, amongst many other things, yes, the Constitution takes care of it, but we saw the Courts Act in 2002, which, like I've described, puts regional tribunals to sleep and sort of eliminated the district and community ones. They were seeking to have that brought back. And so help us understand what that deletion would have sought to serve, and if it was not going to negate the purpose of the bill.
Your observation is right. But our reasoning was that so far as the Act is creating, especially the district tribunal, that was unconstitutional. That was the basis of our argument. Now, if it falls, and everything falls, so be it if it is unconstitutional. So that was our argument. There are other things, but we didn't get there. But because we were there, it paved the way. We were out, it paved the way for them to continue with that. For instance, there was a clause that the bail would be done on a day-to-day. A clause that when a matter is before the tribunal, nobody can make an interlocutory appeal. And all those things, we thought these were unconstitutional provisions that they were inserting in Ghanaian. They were using the back door to bring in what we had run away from it. So how can you introduce a bill that says that the bill itself is controversial, that the tribunal system is controversial, and you seek to fine-tune it so that it will not be controversial? It is already controversial and outmoded at best.
Controversial because of the history during the military days, you'll agree. It has been
controversial because not only because of the history, but again, the current also. You are introducing 3 judges. One of them is the chair, who is a trained lawyer. The other 2 are ordinary people. Even the ordinary people, when we say that we should graduate it to a level, somebody who had gone to a tertiary institution who would appreciate what is before them, at least then the person could be trained. They said no, ordinary means ordinary. And then the law also, the bill also says that the 2, when the decision must be made by majority. So it means that impliedly the 2 can decide against the chair of the tribunal. So you have people, ordinary people, using their emotions, give judgments, and then decide on the fate of ordinary Ghanaians.
Right. There's an argument that's been made that, look, this is positive to a certain extent. It expedites hearings, particularly on matters like Galamsey, which has bedeviled this country. It will lead to a fast track of some of these specialized cases. It will also introduce experts.
Pick it one after. Let me answer that, and then you can continue.
Right. So on the subject matter of Galamsey, for instance, how do you respond?
Right. The Chief Justice. So if you tell me that you are creating a tribunal because there is, you can create a court and say this is a mining court or the Galamsey court. Nobody would have a problem. The other thing that we raise is that the judicial system, the judicial committee that we have, they would want to create the tribunal system or the tribunal committee that will run in parallel with that. Now, if you tell me that they want to expedite cases, it is wrong. You look on concern for Galamsey to go on in this country, and then you say that this is the bill that will solve the problem. No. Rather, the three judges, they are human beings. When you put three judges there, when one of them is not well and the person cannot come to court, then their case may not proceed. So that would rather lead to more delay. We practiced and we knew the problems we had.
What about the argument as to allowing experts be on the panel as well, which can help the chair of the tribunal arrive at a better decision? Some of the argument has been made that if you go to some of the traditional courts, there's a lack of expertise sometimes with regards to the judges, and it doesn't allow for justice to be served. This will allow experts be a part of the panel to deal with specific matters as and when they do come up.
The NDC government must as well tell us that they are doing away with all the judiciary and they are forming ordinary people to be judges in Ghana. If they don't have the trust in the judiciary, then they must tell us and sack everybody. Then we know that they came to power and said they will sack people and that they are continuing to sack people, judiciary included.
Right.
That is what they have to tell us. Because what they are doing is wrong, probably wrong.
Right.
How can you bring a bill? The memorandum of the bill itself says that the bill is controversial.
All right, two quick questions from me. The first is whether or not at the committee level, the Constitutional and Legal Affairs Committee, consensus was reached as to how to proceed with the bill before it made its way to plenary.
We mean a committee level?
Yes.
What is happening to Ghana? I cannot blame any NDC MP there. What is happening to Ghana? I blame Ghanaians. They have the absolute majority, and it's the same ratio we use at the committee level. The others, when they say that consensus was reached, I don't know what they mean by consensus, because the proposals we had made, they said no. And even the suggestion that we should get a highly educated person to be the ordinary person. When the report came, they said, they changed it and said ordinary means ordinary. And I raised it that this is not what we agreed on. So, and then when we came to the house and were doing the second reading, all these issues were raised. And they said the NDC Abana had become Ethiopia. So they wouldn't listen to anybody.
Right. Honorable, my final question to you this afternoon. The Constitution does grant parliaments the authority to create other courts, the districts, tribunals, which was seen also being a part of it. When you raise constitutional challenges, where exactly are they? And will you, should the president assent to this, marshal your forces to challenge this bill when it does become law?
An Accra High Court has struck out an application filed by the Attorney General's department seeking to revoke permission granted to the former Chief Executive Officer of the National Buffer Stock Company, Hanan Abdul Wahab, to travel to London for medical treatment. According to the court, the travel order expired July 12, rendering the state's application moot and unnecessary for determination. Hanan Abdul Wahab was granted permission to travel on July 4, but was subsequently arrested at the Accra International Airport after prosecutors alleged that he had breached aspects of his bail conditions. Let's now go live to the Accra High Court and speak with legal affairs correspondent Fatal Bayaga for more on this particular story. Fatal, so we're learning lead counsel for Hanan Abdul Wahab, Godfred Yeboadame, has been reacting to the court's decision. What exactly has he been saying?
Plea. He is quite surprised that the Deputy Attorney General, Justice Msai, would be on his feet in court trying to move a motion which has already elapsed. In fact, he himself described it as incompetent and said that the Attorney General or the Deputy Attorney General shouldn't have done that in the first place. You can listen to him.
Well, I think first and foremost, the conduct of the state must really be emphasized by you guys. I'm quite surprised that the state will actually behave in this way, conduct itself in a way just to violate a citizen of Ghana in this manner. They, of course, prevented the court order from being obeyed by arresting him and detaining him for the period that you all know, 4 days and 4 nights and all. And then deliberately filed the motion and face it until after the lapse of the order. And I'm surprised that the Deputy Attorney General will come to court and seeking to revoke an order which has lapsed. So clearly that application was incompetent, could not be granted because the order had lapsed. And they orchestrated the lapse of the order because they arrested him, put him in their cells, and they seized his passport for him, prevent him from traveling and all that.
Well, Fatal, so Dami appeared dissatisfied with the court's alleged refusal to compel the state to release his client's passport. Did he explain why?
Yes, so he said that it was a court order that on the 14th of July, his client should return his passport to the registry of the court. But when he was arrested at the Accra International Airport, the Yoko official seized his passport and all of that. So that's the reason why his client is unable to bring the passport to the registry of the court. So he was saying that he's baffled by the court decision not to compel the state to bring the passport to the registry of the court. We can listen to him.
The reason why I'm quite baffled by what the court did today is that, well, the order for the passport to return to registry was actually given by the court, was part of the court's orders, both at the time bail was granted to him and also at the time this order for him to travel was granted, that after traveling he should return the passport by 14 July. And that has not been done because Yoku arrested him and is keeping the passport. So if the court is not interested in ensuring a compliance with this order for the passport to return to the court registry, I do not mind. We will not make any application at all to the court for any passport to release. It's up to the court. If the court doesn't want the passport to return again to the registry of the court, so be it. At the appropriate time, when there's a need for him to travel, we'll make an application to the court for him to travel. That is all.
But the judge said you know what to do in order to get this passport.
It's up to the court. The judge was concerned about the seizure of the passport by Yoku, and the judge failed to order Yoku to return the passport to the registry of the court, in compliance with the court's own earlier orders. And if now the court is not concerned about the compliance of its own earlier orders, I don't have any problem. It's up to the court. I mean, they ought to know what to do and to do the right thing. The republic must not be pleased all the time. It's about time the republic be called to order.
Fatal, talking about Yoko, so Hanan Abdul Wahab's £7,000 and other items are still allegedly being held by Yoko. Did the lawyer address this?
So according to Yeboadame, he doesn't know whether this money has been spent by the Yoko officials, and that's simply the reason why they do not want to release it at this particular point. So he said he's quite worried that this is happening, and in fact, he explained that, in fact, this money wasn't taken out from the alleged frozen account. This was the money that borrowed to travel to UK for medication and all of that. So he said, going forward, they are considered some legal remedies in order to get the money and the other journalists.
You cannot arrest a person and seize money which is on him. They've seized his money. I don't know whether they've spent the money, Yoko has spent the money or not. I mean, the money that was not taken out of the account that they claim was frozen. Clearly, the account that was frozen was not assessed because there was no check written by Hanan to withdraw any money. He borrowed money for his travel, about £7,000, and they've seized it. And they've seized it with Yoko, the executive director. So these are the matters that are pertinent.
So you are close to your client. How does it feel about all of this situation at the moment?
Well, he's keeping it cool. I mean, definitely he knows that he's not guilty of any crime at all. And in the fullness of time, he'll be vindicated. And that's the most important thing.
And I mean, with regards to the arrest, you indicated that no charges have been pressed yet.
Yes.
Something that you're going to follow up?
Yes, so the law gives us a number of options. Enforcement of his fundamental human rights. We can institute an action for unlawful arrest and for damages for all the injury and the harm that has been occasioned him by the unlawful detention. Well, I think first and foremost, the conduct of the state must really be emphasized by you guys. I'm quite surprised that the state will actually behave in this way, conduct itself in a way just to violate a citizen of Ghana in this manner. They, of course, prevented the court order from being obeyed by arresting him and detaining him for the period that you all know, 4 days and 4 nights and all. And then deliberately filed the motion and face it until after the lapse of the order. And I'm surprised that the deputy attorney general will come to court and seeking to revoke an order which has lapsed. So clearly that application was incompetent, could not be granted because the order had lapsed. And they orchestrated the lapse of the order because they arrested him, put him in their cells, and they seized his passport for him, prevent him from traveling and all that.
Anyone who say we na ya be for street so a who cause who defending yankoye one say we nim nyansa. Hwe lori kwan ya wonam so. Hwe baby a wonam ani ne awudi akire one say we nim nyansa. Edi wona we MPP ni ba mapa na wa bre na mo ye founding fathers of the party and the latter day saint what was japade o maye. It is some ranchi wa baba kacha ye massa ye yambobra. Say the political office at the mawa. Anunti anya even kura no Bible kura akire say e twa say nipa be wu na owu echi atemu ewo. Enti ade bia ye de ahye wonsa say wo say wo ye no sa de kode no at the end of the day I was so ubu akonta. Why ye juma bebu akonta MB before said there be na yansu yaba ye mubi. Say because you agree way say anya MPP na party asenso de ya aboa wonwo nguremu a. Yey. Ena mu ye ya yesu be ye mubi. Enti gomunja mu na mu wi a. Sena beya abai no so kwa na musu mejawo. Is that the mindset? What was why lem and I want to ho? And when you listen to the pro MPP media houses now, yan kan yansa se bia nkyerɛw. Yasi ni entia Dennis Mirakrabwaje ya chini nyina ne say in 2012 John Dramani Mahama ati secretariat bi a secretariat na ya tie no eno ena aya Nanado Danko Kufado abaye no ano use the same secretariat say ya ba the regions na regions ni aba beti no Dennis Miracle Abwaji anya CEO Anonya onye CEO awosa secretariat no IMMC na sa secretariat no ana eya omu atiye no mami fa amau na hunu nti a ye che no tie aya interministerial coordinating committee on decentralization. Now, yet in 2012, first executive secretary, Dr. Callistus Mahama. Now, another Azumi office, no, and Yadima, near Dennis Mirakrabwaje, somewhere in 2022. Sir, Omedano, now, Branch Webedano, ɛna aban asisaye. So in 2025 NDC take over no. Aya the new executive secretary Dr. Gamali Kudibe Hodofia onu anoye current executive secretary anosi there be amranche bi betena ha na womu na mu ye adwuma na misusu se ansa na maba betena se executive secretary no e was say yenya nhwehwem wo mu ndwumadi o mu adim ampa wo mu ye nhwehwem no ana o mu hu se Dennis Miracle Abwaji ana accountant one other staff omo ho no omo di dwim omo wie sika tie ni ye etu ye junkie me e de wa kwaso asukọ no ma meka say wo junkie ya wo di echi ko wo 50 plus years wo 60 years wo 70 years wo yamu ba 41 years yesusu se we wie sika wo kwaso ye nja no wo nim nyansa ye enti aya accountant no de wagye to sam pa sika no omo podwe ana wo sha asese otua Dennis Miracle Abwaji ye aware all the time bia okoyi oku ho na omu already achiwe wasamba betra radio so there say ora no anye adwuma Abushia you're from Alaska the commander with a commanding voice here we speak to power. Na yamaga na hu MPP as a political party a criminal organization